From the Library of Congress in Washington, D.C.
Good morning, everyone. Thank you for coming. My name is Reagan Smith. I'm Deputy General Counsel of the Copyright Office, and I, along with my colleagues, will be presiding over this hearing, which is part of the 7th Section 1201 rulemaking. First, let's introduce ourselves, starting from left to right.
Jason Sloan in the Copyright Office.
Julie Saltman, Assistant General Counsel in the Copyright Office.
Kevin Amer, Senior Counsel in the Office of Policy and International Affairs.
Anna Chauvet, Assistant General Counsel at the Copyright Office.
And I'm Rafi Goldberg from the National Telecommunications and Information Administration, which is a mouthful, so we usually just call it NTIA. And we would just like to thank the Copyright Office for allowing us to participate in these hearings once again. Thank you.
And we're again very grateful NTIA is here and participating in this with us. So we are all excited to be here today and hear all of your evidence. I know some of you, I see some familiar faces, but also some new faces, so I want to explain how the process will work. As you probably realize, the goal of these hearings is to try and analyze and further develop the record in relation to the proposed exemption to the anti-circumvention provisions in Section 1201 of the Copyright Act. We're more interested in clarifying and developing the record rather than going over arguments which were already seen in the written comments. It's helpful if we can use this time to hone in on the issues, particularly disputed issues or areas where the record may be a little bit patchy. And some rules of the road: make sure to speak into your microphone, speak slowly because there is a court reporter and also this hearing is being live streamed. I will be calling on people or others will be calling on people, so if you would like to speak or make a comment, just tip your placard up and we'll know that you want to speak. We'll try to call on people in turn as how they've raised their placard, but either way, we'll make sure everyone gets a chance to speak. I think no one has exhibits for this hearing, but for future panels and looking at the audience, we will mark exhibits prior to that. And in terms of audience members, we also have a sign-up sheet for audience participation, which will be Thursday or Friday. So if you're interested in speaking briefly on one of these subjects, you can fill out a request so we can make sure to accommodate you in the time. The microphones, we can only have 4 on at a time, and I believe if you have 4, you might start to get some weird feedback. So if you can, just try to press the button to turn off your microphone after you speak. So I think, unless there's any questions, we'll start by asking the panelists to identify themselves and any affiliation or interest that you have, and then we'll start by asking some broader questions to try to get at the issues. So Mr. Keeley?
Mike Keeley, Dorman Products. I am Executive Vice President of Commercial, so I have responsibility for all of our product development initiatives for both new and remanufactured aftermarket auto parts.
Jonathan Band, I'm here on behalf of the Owners' Rights Initiative.
Andrew Shore, I'm here for Joe Marion, the Association of Service and Computer Dealers International, and in full and fair disclosure, I'm also Executive Director of the Owners' Rights Initiative, and ASCDI is a member, so you'll need a program to keep it all straight.
Thank you, we appreciate that.
Aaron Lowe, I'm Senior Vice President for Regulatory and Government Affairs for the Auto Care Association.
Matt Williams, I'm with Mitchell, Silverberg, and Knupp. I'm representing AAP, ESA, MPAA, and RIAA.
I'm Bruce Turnbull with the Turnbull Law Firm, representing, as it says, AACSLA, but also this morning the DVD Copy Control Association, who filed joint comments.
Okay, thank you. So I think everyone knows, but the Register of Copyrights has already determined that she can recommend renewal of the existing exemption for repair. So here today, we're here to discuss potential expansions or modification of that current exemption. And I think we'd like to take it in pieces based on general issues. And the first pieces we'd like to discuss are third-party assistance and manufacture and provision of tools. And so I guess my first question, pretty broad, is the Copyright Office has said in its study that Congress should consider legislative clarification to allow for third-party assistance. Would anyone like to explain why the proposed expansion would be within the scope of the office's authority as opposed to abutting against the anti-trafficking provisions, or not within the office's authority? Mr. Williams, and just tip your placard up next time so we're
Sorry
sure
about that.
that you're trying to speak.
I would take the side that it would not be within the office's authority at this time. I understand there's a proposed legislative amendment, but in the context of this rulemaking, I think the office has been correct to say that it should not and cannot issue exemptions that are likely to be interpreted to encourage trafficking. I think the focus of the proponents' arguments on this issue was that the statute refers to users of works as opposed to owners of works or copies, but there's a number of ways to explain that without saying that Congress intended to mean that a service provider could get an exemption. For example, Section 117, you've dealt with that issue about whether an owner or a user / licensee could get an exemption. There are also people who access streaming media content who are not necessarily owners of copies but are users of a work. And so there are other reasons why Congress would make that choice aside from allowing services exemptions.
Mr. Band?
So I think you have to look at Section 1201 as a whole, and as you say, that you have the anti-trafficking provision, but at the same time, we do have this rulemaking. And if you looked at the anti-trafficking provision literally, it says, you can't make or traffic, right? You can't make or distribute a circumvention technology. Now, certainly, anyone who is granted an exemption is going to have to make a circumvention device, right? I mean, or have to come up with the software or do something that allows it. And so you have already, so arguably already, the statute is a null set, right? That you have a rulemaking that allows an activity that is, or that allows an activity, but then the anti-trafficking provision prohibits the development of the technology that allows you to engage in that activity. Now, you've taken care of that problem by saying, well, no, it can't possibly mean that, taken literally. And so you've interpreted the trafficking provision in such a way that it is not in conflict with this rulemaking. Okay, otherwise the rulemaking would be an absurdity.
Well,
but let me just finish that thought. But given that, it seems that you can easily interpret the authority under the rulemaking to allow not only the person not only the owner of the work to engage in the circumvention in order to get access to the work, but to allow someone, a third party, to help them, just like courts have found that the fair use privilege can apply to someone, not only to the person who is the ultimate end user, but someone who is providing a service to that end user.
So you've brought up a couple of issues, including making it personal to how the office has looked at that, as well as third-party assistance. Is it your understanding that the Copyright Office could just allow an exemption for someone to distribute a technology, product, service, device, or component, the list of things prohibited in 1201A2 or B under 1201A1?
Well, I think it's a matter of how far you're willing to stretch the statute. So probably
we're not looking generally
right.
to stretch the statute.
Right.
So
No. But look, let's be real. I mean, you're already sort of engaged in creative interpretation to allow the people who get an exemption under 1201A1 to make a circumvention technology, right? Because they can't just it doesn't appear It doesn't come down from the sky. I suppose you
Right.
could say, yes, well,
We
it does.
we said
I
it
mean,
was
usually you
implicit
can-
in the statute.
Right,
So
exactly. So
while
the-
we endorse creativity generally, we're not, that was not our goal. Our goal is to just read the statute plainly. So did you have a question?
Well, yeah, could I just follow up on that? So, I mean, I think we said in construing the term manufacture, we read it in light of the term trafficking, and we said that the term trafficking as a matter of general, definitional meaning generally refers to commercial activity. And so if you're talking about manufacturing a tool for self-help, we think that manufacturing wouldn't cover that if you're a beneficiary of an exemption. I think that the challenge for us here is if we're talking about providing a service, and if you're talking about a third-party service provider, for example, that is likely to be a commercial entity. And so the distinction, that we drew in the context of manufacturing doesn't really help for purposes of allowing commercial third parties to provide assistance. So I think that's kind of what we're.
Well, I guess I would
struggling with.
respond that the term manufacture you could construe it to say, well, if a repair shop, well, just like you're saying, a user, if he manufactures it for his own purposes, it's not a manufacture. I think you can certainly also say that if a repair shop develops the circumvention technology, but it's not selling it, meaning it just develops the technology
How is
itself.
the repair shop making money if it's not selling its services?
It's selling its
technology?
services, but it's not selling the device.
Okay, Mr. Turnbull?
We've tried to find where a fine line might exist, and in our view, the term user can be interpreted to be an expert repair person. Where we draw the line, however, is we would object to and think the office would not have the authority to grant an exemption for somebody rendering assistance. So if the product is physically brought to a repair facility and the repair facility has the physical product in its possession and is then using the physical product, that literally, in our view, would be acceptable under the statute, whereas if the repair person is rendering assistance in some other manner, then you probably are over the line. But and this is one where we're mindful that our interests with DVD and Blu-ray players, it may be a little different from some of the situations presented by, farm equipment or autos and that sort of thing. And while we have no position on those exemptions per se, in looking at the commentary, our view has been that you can read the word user in the way that the study report suggested that you might, particularly if you then take the further view that manufacturer has can be read in the context of the trafficking word as well.
So just to clarify, Mr. Turnbull, do you understand that a third-party repair person providing assistance, as you described, as a user, would they be able to provide both repair assistance and repair to add improvements to a device? Or do you think that a user just has the ability to repair?
We are very concerned about the possibility of improvements, and in fact, in our comments, and I am mindful of not repeating, but in our comments, we did make the point that modifications that would actually enable certain kinds of functions that have been the subject of previous requests for exemptions, that certainly should not be allowed. Now, whether there are certain kinds of where you could draw the line, I don't know, but we would for sure say that, for example, adding functionality that, for example, a DVD player or a Blu-ray player would not allow access for certain purposes, and modification to allow access for those purposes should not be provided.
So assuming something was non-infringing under Section 117 or 107, and we can later discuss whether modification is always or sometimes or never within those bounds, AACS believes that if a service shop or an independent repair shop provides services, would it be at the direction of a user, or what would the statutory language be?
Our line is that if the repair person is in fact using the product, not providing services in support of the owner of the product, but if they have physical possession of the product, then they are the user of the product.
Well, so if I take my car to a dealership and I say, I want you to fix, the lights on the Fritz or whatever, they are both using my product and providing a service to me. So how would that work in practice?
At that point, if they're within the terms of the exemption.
That's what I'm asking you, would they be?
No, well, but if what they're doing, in other words, if you gave an exemption to the user of the product to repair, the lights, just to take a non.
Well, I think what we're talking about is whether or not currently it says you can engage in repair, diagnosis, maintenance by the owner of a lawfully acquired device, and if we said by the user of who has lawfully acquired a device, in this instance of the independent repair shop, do you believe that's an exemption that the office could do that would still remain within the statutory mandates of 1201A, or do you think it would go beyond that because it would be condoning anti-trafficking?
I think read literally, it's within your authority.
Okay. Mr. Shore?
Thank you. Just quickly, I guess, and I look at these cameras right in front of us, for instance, I don't think that there's anybody in this room who, if they own this camera, could repair it. Given the advances in modern technology and the complexity of the things that we own, third-party repair is totally necessary. And so if you didn't read the statute to allow third-party repair shops to engage in services for goods that the individual owns and brings to them, then why even have the rulemaking? There are, to be fair, there are cars from the 60s still around that people can repair themselves, but even my 2010 has technology that I wouldn't even start. I lost the key and I couldn't unlock my car because of the complexity of the technology.
So the Copyright Office has acknowledged sort of these policy-driven issues in our 1201 study, and I think right now I'm trying to just nail down our statutory basis, our regulatory authority, how far it might extend, because we recognize that this may be something of use. So I think that's what we're trying to focus on in this part. So maybe Mr. Williams, then Mr. Keeley.
Thank you. Although I almost always agree with Bruce on this issue, I don't think I can if I'm understanding his position correctly. In that scenario that you were discussing with him, as I understand it, the repair shop would have somehow acquired the tool, not necessarily manufactured it, and then they would, for money, offer the service of using the tool to circumvent and repair products. And while I'm not here to specifically address automobile-related issues, my understanding of that scenario is that it would always require circumvention in order to get to making the repair. And in that instance, if you look at the language of the anti-trafficking provisions, that would be providing a service for the purpose of engaging in circumvention. And I don't think that your statutory authority goes that far that you can grant exemptions under 1201A that, as you've said before, are very likely to result in people going out and engaging in trafficking. I think you hit the nail on the head a second ago when you said you've done your work in the policy arena, you've provided the report to Congress, something may or may not come out of that. But I don't think the fact that you reached one conclusion in that arena should change your regulatory authority in the proceeding.
Well, so that's helpful. I mean, I think the argument, that we've heard sometimes from the other side is that, if you're talking about something like a repair shop, is that a service that is primarily designed or produced for the purpose of circumventing. Now, as I understand your position, I think you would say, well, circumvention is never the ultimate goal of a service, and so, even if you're circumventing for the purpose of allowing piracy to take place, that service should be understood to be primarily designed for the purpose of circumvention. But, I mean, what about that concern? I mean, if you're even thinking about the concern Mr. Shore raised, just sort of the practical need in many cases for third-party assistance, doesn't the statute suggest that there are some types of services that should be understood as not primarily designed for circumvention, but that nevertheless sort of incidentally involve circumvention?
Yes, I think to say otherwise, you'd have to read that language out of the statute, which you can't do. On the other hand, as I was trying to say, my understanding is that in the auto repair arena and in many of the arenas that we would care about, pretty much every act involved in that service would result in an act of circumvention. And so it's not that they're, engaging in a service that occasionally happens to involve circumvention. It's that by definition it involves circumvention. So in that scenario, and probably others, but at least in that one, I think it would violate the trafficking provisions. And I also, again, think that the office has been correct to say that it's not just let's read strictly the trafficking provisions, and then if there's some argument that maybe something doesn't fit within them, you grant the exemption. I think it's the other side of the coin, which is that if it looks like trafficking, you're supposed to stay clear of it and not encourage something that is possibly going to lead to trafficking.
Yeah, but so I mean, you're agreeing that there is some class of services that incidentally involve circumvention that wouldn't fall within the trafficking. So I think what we're struggling with is trying to figure out how to draw that line. It seems to me that, I don't know, one could argue that if you're, circumventing for purposes of fixing a car and then you put back the TPM, for example, you unlock the product, and then, I mean, is that a way to distinguish services that are primarily designed for circumvention compared to those that only incidentally involve circumvention towards some other end?
I don't think that would be the defining line for what's primarily designed for circumvention, although we did say that if you ultimately decide to grant some kind of broader repair exemption, that the 117D factors for defining repair would be more helpful than some less bounded definition of repair. I think that because the statute refers to primarily designed, you have to assume that theoretically there is such a service. I couldn't tell you one sitting here today, and I don't think I've seen any in the record. I think you very accurately described our view, which is that circumvention is almost always going to be for the purpose of achieving some other goal. So no one is really going to be in the business of circumventing just to show people they can circumvent. And so if you define it in a way that says, well, really my goal is repair, or my goal is some other activity, that's not enough in our view to take you outside of the trafficking.
I wonder if maybe Mr. Keeley could speak to that, because I see A2 also says there's only limited commercially significant purpose. I'm wondering if especially in the vehicular context, if the tools for circumvention are more connected towards, diagnosing what's wrong with the car or repairing something, or if they are if circumvention is one act and then the acts of maybe more traditional auto repair or diagnostics are separated from that.
There are a couple things in there, so I'll try to deal with each of them. So if I could just go back real quick, you had asked the question as to whether or not it was in the Copyright Office's jurisdiction to sort of extend the exemption. And one of the things that's concerning to us is, the existing exemption as it references vehicle repair, extends the exemption to the motor vehicle owner. And we would sort of agree with the report to the Register of Copyrights from June of 2017, paragraph page 4 in the executive summary. In cases where beneficiaries cannot themselves make use of an exemption, the office believes it is important to allow users to seek assistance in making use of that exemption. So with respect to automotive repair, modern vehicles today have somewhere between 50 and 70 complex computing devices on them. They perform all sorts of functions, from rolling your window up and down to the braking system on the vehicle. And if one of those computing devices goes bad, the motor vehicle owner does not have the tools or aptitude to be able to fix the hardware failure in one of those devices, put that device back onto the vehicle, and then put the software that was on that device back on to a repaired module. There's just no practical way for them to go about doing that. So without being able to extend that exemption to a third-party repair facility that can perform that repair on their behalf, the exemption is effectively useless. And so for us, one of the things that we would like to see clarified in the exemption is that right can be extended to a third-party repair provider, or for the exemption to remain silent with respect to the motor vehicle owner.
So that's helpful. I mean, I think, the challenge for us is we're obviously not granting or recommending exemptions for purposes of the trafficking, where that's clearly outside our authority. Everybody agrees with that. But, I think nevertheless, if we were to sort of recommend an exemption that might allow for some third-party assistance, we would need to have some theory about the trafficking provisions and how they should be interpreted, and some way to differentiate services that are provided by a third party that are not trafficking versus those that are. And so I think, your points are well taken, I think, from a policy standpoint. But I think from our perspective, we're trying to understand what your theory would be, or what you're suggesting that we do in terms of interpreting the trafficking provisions.
With respect to automotive repair and diagnostics, I think the software that we're talking about is effectively useless outside of the device that controls the vehicle on said vehicle. I can't think of a situation where somebody would want to traffic in vehicular software, especially with respect to specific computing devices on the car. If the exemption was limited to repair and remanufacture of specific devices and repair of the vehicle, I don't know if that doesn't sort of put a bow around the issue.
Okay, thank you. So Mr. Brand, I'd like to let you chime in, but I also have a question for you about Mr. Keeley's comments. He said without third-party assistance, this exemption would be fairly useless, which I was surprised at, because the last rulemaking and in owner rights initiative comments, there's a lot of emphasis over, both the personal American tradition of souping up or fixing one's cars and self-improvement, as well as this is listed as a basis under 107 for personal education to engage in, taking apart the software and playing with it. So do you want to speak about whether you agree with him or disagree that individuals can make use of the current exemption or an exemption for repair?
Well,
I know that's sort of two questions.
Right. So first of all, let me respond to that. So I think, I guess the answer is it depends. It depends on the car. It depends on the individual. Certain people obviously are better equipped at doing these things by themselves than others. And also we're interested in broadening the exemption beyond the automotive sector. I mean, our focus has been on a much broader exemption, that if you're talking about embedded software, which was not what anyone intended when 1201 was drafted, that's the kind of thing that people should be able to circumvent or get assistance. But certainly some of the, with cars, that's probably on the more complicated end of the spectrum, but some of the devices that we're interested in and that have software in them are much simpler and are, conceivably an individual on his own or with, after watching a YouTube video would be able to figure out how to fix by themselves. So I think it depends. Certainly cars are probably on the high end of the spectrum, but there's a wide range of spectrum of devices that have embedded software. But turning back to what Mr. Amer and Mr. Williams were talking about and so forth, it seems clear when you look at the statute, the trafficking provision talks about a service that is primarily designed, right? Or it has a limited commercial purpose other than. I mean, it's talking about a circumvention service. That's the service. And to the extent you can say, well, no one's only going to just circumvent and do nothing. Well, right. The point is to circumvent and then engage in infringing activity. That's what it was all about, right? Remember, this is about infringement. That's what the statute is designed. And if not infringement directly, then circumventing to get access to something you haven't paid for, right? That's what to the extent that when 1201 was broadened beyond, what was 1201B to include 1201A and get into access control, it's like getting cable without, sort of like tapping into a cable signal or tapping into a satellite signal without paying for it, getting something you weren't entitled to pay. That's what it was intended. And I think as you're interpreting the statute, you need to say, okay, what was this really all about? What was the intent? And it was intended to, let's say, deal with a service where someone would come out and circumvent the cable box so that you could get, HBO for free. That's the kind of service you're not allowed to engage in. That's a trafficking or that's the kind of service that 1201A, the trafficking provision of 1201A was designed to get at. Here we're not talking about getting access to something you paid for. You paid your $50,000 for your car, and now you want to get it fixed because
Do you think the same would be true if it's like a rental car? I mean, just foreshadowing, you've requested to expand this to other devices where it's less, maybe the ownership indicia is less clear. Does that make a difference in your analysis of whether these activities are likely to be non-infringing?
Well, if it's a rental car, you go back to Hertz and say,
hopefully,
give me my money back, right? I mean, certainly in the typical context where you're, the owner of a device, you've paid your money for it, and you want to, you don't want to go back to the dealer who's going to charge you 3 times as much to repair. Once you're out of warranty, right? The dealer's going to charge you, 2 or 3 times as much for every repair. If this is your car, you should be able to fix it, and this was not what Congress intended, and you should interpret the statutes in a manner that would allow a person to exercise their ownership rights.
Thank you. Mr. Lowe, and I'll just sort of bundle a question to you also. Your comment has asked to add in language regarding the provision of tools, and I'm just curious at what you think adding that language in, what it would allow people to do that they can't currently do, because the Copyright Office has said individuals should be able to make use of a tool in order to effectuate an exemption, and then separately we have raised these questions about regulatory authority for third-party assistance. So my question is, if we added in language allowing for provision of a tool, is that in a commercial way of selling it, or is that just to clarify that a user can use a tool when they're engaging in the circumvention? I'm not sure what would change.
I guess we were looking at the development of the tools so that the technicians have the tools they need to work on the car. I want to go back to the comment, when people are repairing cars, the whole goal is to get that car workable again. There seems to be an assumption that, that they'd be trafficking for illegal use. The assumption should be they're going to be using it for legal use, because there's little to be gained from any other use of those, of the circumvention exempt issue. So we think that if there are people that work on their own cars still. There is a active industry of, and it's regulated in California and nationwide, where people receive executive orders to produce parts that are different than the original equipment part, but also are legal because they don't create problems for emissions. So there are a lot of legal uses that have already been developed, and a system that's been developed to allow for do-it-yourselfers, for modifications, and for getting those cars repaired. So it should be, the assumption that if there's any trafficking, that can be taken on an individual basis, but that for the most part, in nearly all cases, it's being done for legal purposes. As far as the tools go, if the shops or the individuals don't have the availability of the tools to work on these sophisticated systems, and that the parts can be tested and the tools can be tested, it's going to be very difficult for individuals or repair shops to do the work. And I guess I would differ in that I think the answer is both, is that if you take the exemption, if you don't expand the exemption, that is going to create a lot of problems for a lot of motorists. But there are also car owners. It's both. Car owners also work on their cars. Now, it's a smaller percentage than it used to be, but it's still there and it's still a vibrant industry.
Thank you. And just while I have you, one more question on a slightly different topic. You've asked to list out vehicles beyond motorized land vehicles to talk about light, medium, heavy-duty trucks and construction machinery. Do you think that's not permitted under the current temporary exemption, or why would that regulatory change be advisable? I mean, it says motorized land vehicles. Doesn't that include a truck?
Yeah, I think just to make sure that those are mostly done by repair shops that work on those cars. They're not done by the actual owner of the motorized.
But if it's currently permitted, is it change? You would say it's currently permitted under the temporary exemption.
I think we would just want to make sure it's covered.
Mr. Lowe, I just wanted to clarify regarding tools for independent repair shops. My understanding is that under the memorandum of understanding that is part of the rulemaking record, the independent repair shops do have access to the tools that they need. What evidence in the record, or what evidence is there that they need additional tools that would not be licensed from dealers, or from, manufacturers?
Well, I think right now you're saying that the only place they can get those tools are from the manufacturer under the MOU, and that availability is there, but there's no competition. And so, I think the vast majority of shops get their tools really from outside other sources. The right to repair, the MOU is to make sure that because the cars are becoming more sophisticated, that there would be the choice that they could go to the car manufacturer's tool and obtain it. Right now, you're asking for software updates. When you have to replace the software on a part, because it's all, it's almost all software driven now. They buy the software when they buy the car, but then they have to go and buy the software again when they buy the when they buy a part to put on there from the manufacturer. So there's really, it should be that there should be competitive availability of both parts, tools, for the independent, and that's what keeps consumer choice and what makes repair affordable for Americans.
So, and I guess just to clarify, you said that repair shops are getting tools both from the manufacturers and from other sources. So what tools are currently prohibited by the exemption that you think should be included in the scope of the exemption?
Well, I think any tool, I think the biggest problem is in the reprogramming and recalibration area, where you have to buy it from the manufacturer. And the manufacturers have tightened up the rules in a lot of cases to get that recalibration. GM just released a new rule, a requirement that you have to pay per VIN number for each calibration. They used to do it on, you could get it for a month for any GM car. Now, the owner or the shop who's trying to recalibrate is now has to pay per VIN number for that calibration. So there's a huge profit center now for the manufacturers in just being the only source of being able to download a program onto that replacement part. Recalibration is when a program, when you replace a part, the part has software on it with the program. They come with a blank chip on it so that it's programmed to work with the rest of the parts on that car. So you have to download that program onto the part again after you've replaced it. But it's basically the same program in most cases.
So just to clarify, Mr. Lewis, are you saying that repair shops can get the tools from manufacturers, but that's just too expensive for them to get it that way? And then I guess the other kind of second part of that question would be, well, wouldn't that expense just be paid by whoever is having their car fixed?
Well, they're all competing. I think you could say that the car owner benefits in the fact that they're competitive sources for both parts and tools. And because they can get the same repair done at an independent, using an independent tool or an independent part, that would benefit in having that competitive advantage. If you're making a commodity where you get the same service, then the car owner is going to pay a higher price all the way across the road line. So, yeah, I guess you could say they could get that repair done, but at what price? And you're taking away that ability to compete.
I'm not sure who is next. Maybe Mr. Williams, you're getting pointed at.
Yes, I was going to get back to something Jonathan said about things that go beyond automobiles. So if you want to stay on autos for a while, I can wait.
If we can stay on autos a little bit, I think maybe this
Sure.
may be last call on third-party assistance issues, and then moving on to the telematics and entertainment issues, and then we'll get to broader devices. So, Mr. Shore, did you want to contribute?
Just a last word on third party, and I wanted to go back to your original question about looking for a theory that could harmonize this and give you the authority. Why not read it against the first sale doctrine? Because the idea that you can't, with such complicated technology, again, not on autos, I'll keep pointing at the camera because it looks so complicated. And it's
looking right at you.
And it's
I think
looking
someone's
right
going to
at
try to
you.
repair this camera after the session, and you've kind of thrown down the gauntlet.
Right. So if I own that camera and I couldn't use a third-party maintenance provider to repair it, then it negates my rights under first sale. I think that's one way to look at it. And then we end up just winnowing down what you can transfer under the first sale doctrine, ultimately nothing that has any sort of complex embedded software. Thank you.
Well, but could I just say, I mean, the first sale doctrine is a limitation on the distribution right. It doesn't, allow you to make an adaptation, of something that you may own in a physical object. So I don't know that would really provide a theory for us to, conclude that all of the activity that you're talking about is going to necessarily be non-infringing.
Well, but my point is that the first sale doctrine is totally negated. If you're looking for a way to, you asked the question, how do you harmonize this, right? And why even have a first sale doctrine then if you can't circumvent technology using third-party maintenance, as we, I think, generally agree that most technology would require third-party maintenance. All you're doing then is selling a brick. You don't really own that thing if it has no value because you can't repair it. Anyway, I'm going to hold it. Thank you.
So let me actually ask you what do you think about an alternate theory as well as others. So Section 117 says it's not an infringement for an owner or a lessee of a machine to make or authorize the making of a copy in order to do a machine, a repair. So I guess my question is, if a mechanic is making a non-infringing use under 117, and they have to circumvent an access control in order to make that use, do we think that there's still potentially a trafficking in a circumvention service, or are they just the non-infringing user of the software, undertaking circumvention, which is it.
No, I agree. I mean, I think that that's a perfectly viable basis for interpreting the trafficking provision, that it should be done in light of the other provisions of the Copyright Act, like for sale or 117. It certainly informs what should be seen as the scope of what's being prohibited, and it certainly makes sense if you're going to be circumventing, if the service that's being provided is a repair service, and you incidentally have to circumvent in order to provide the repair service that is clearly lawful under Section 117, then the trafficking provision should not be interpreted in a manner that would prevent that. Or certainly the rulemaking, given that, again, Congress decided that there should be a rulemaking, if there should be exemptions, it should all be interpreted so that it all fits together.
Okay, Mr. Williams.
Yes, so I think that's a very good question, but I would say that the courts have been pretty consistent about saying a defense to copyright infringement is not a defense to a Section 1201 violation and a 1201A2 trafficking violation. So I don't think that the argument that 117 would apply as a copyright affirmative defense means that the office can go and grant an exemption that's likely to encourage trafficking under 1201A2. The other thing that I would note, although we wouldn't support an exemption that did this, is for 117 to apply, they would have to restore the product to the original state of operation under 117D, which is something the office has proposed in its policy study, and so that would be a wrinkle there as well.
Sure, I guess just to, sort of put a, and I know we've been talking about this for a while, but, if my check engine light is on and I take it into a mechanic, and in order to make the repair to restore it to, the way it was working before, he has to circumvent an access control. Is he trafficking, or is he just a user?
Yes, I believe, as I was saying earlier, that it would involve trafficking for a repair shop to sell the service of accessing a work by circumvention in order to engage in some further activity that the user is asking them to engage in. As I've said, we're not primarily focused on automobiles. My clients are not, but this has effects in other areas as well. And as I was discussing with Mr. Ammer earlier, if the goal is ultimately to say, get an unencrypted copy of a movie, and the argument is, well, the circumvention is just peripheral to that, it's not really my goal, that would cause significant harm. And it's basically the same theory that's being offered for some of these trafficking exemptions. So I think I'm worried about a slippery slope here, and that's the primary focus of our opposition to this.
Thank you. So just to be mindful of time, I do want to move on to the next topic. So Mr. Keeley, I'll call on you first, but if you can transition what you're going to talk to, maybe respond to Mr. Williams if you desire. But the question to you is about the request to allow circumvention of the telematics or entertainment ECUs, and I want to know whether the current exemption precludes that, and is that preventing repair, diagnostics, or lawful modification of the vehicles as opposed to perhaps entertainment content accessed on the vehicles?
So I think that, to me, the telematics modules or the infotainment units on the vehicle are no different than a brake control module. In terms of
Are they separate modules?
There are separate modules, but in terms of how they need to be repaired on the vehicle. So if the vehicle owner has a failed infotainment module, they just want a repaired infotainment module that's in the same working condition as their current infotainment module had been to be replaced into their vehicle. No different than they would want a repaired brake control module to be placed into their vehicle.
So it sounds to me like, in a sense, I don't know if one phrase we're talking about is layered TPMs, but what you would need to circumvent in order to repair the infotainment module is separate than what you would need to circumvent to repair the brake system or the oils or the engine or other parts of the car.
No, I think they're the same. That's why for me, it's difficult to draw the distinction between the two.
What are you circumventing?
So let's say the vehicle owner wants to replace their infotainment unit. That infotainment unit may be the same physical device on a Cadillac Escalade as it is on a GMC Yukon. What makes it unique to the Escalade versus the Yukon is the software that's loaded onto the device. So let's say the end user decides that they can physically perform the repair, right? They can remove the old one, they can put the new device in. That end user had no way to transfer the software that was in complete working order from their old device to their new device. There's no way for them to complete the repair, right? They can physically do it. They can take the old one out, they can put the new one in. But once they put the new one in, it's not in working condition because it doesn't have the software on it. Right? They need a way to be able to transfer the software from their old device to their new device. I mean, think about, to draw an analogy with the laptop. I mean, if you have a hard drive failure on your laptop, you can replace your hard drive, and you can you can transfer the image of your old disk to your new disk. There's no way for anyone to do that with the modules on vehicles today, and that holds true whether it's an infotainment module or whether it's a braking control module.
So, is your business getting requests to transfer infotainment modules, or is this something that you've looked into doing but can't do because of Section 1201, or?
We certainly get requests to produce repaired infotainment modules.
Okay.
But we do not do them because there's no way to actually allow for the end user to complete the repair. So we could physically repair the device, but if we can't give the end user a way to actually turn that into a working product on their vehicle, it's not commercially viable.
What circumvention would be involved if you were to do that?
The only circumvention would be to give the end user a way to bypass the circumvention features and move the software from the failed unit to the new unit.
Okay, and it doesn't sound like, I'm not sure if you understand, like, is there specific technology you can reference? And if not, that's perfectly fine.
I cannot reference a specific technology, no.
Okay. Mr. Lowe? Or?
Mr. Keeley, I just had a quick question of clarification on that. So to reinstall a new entertainment module, would you need to circumvent the TPM, the same TPM that you would need to circumvent to repair the brake module, for example? I guess I'm trying to understand, is this a different type of TPM a different TPM that's being circumvented, or is it the same one? It's just for, to incorporate the entertainment module as opposed to like the brakes?
I don't know if they're the same TPM or they're not, but they're, you have to bypass the circumvention feature on both.
Okay. Mr. Lowe, do you know?
I don't know the exact technical.
You can turn on your microphone.
Sorry. I don't know the answer to that question. I was going to add that, the telematic system is more than just the entertainment module. And the importance to the industry of the telematic system is growing because the vehicle manufacturers, the OBD port that we've used to obtain diagnostic information is going to either be limited to only the required emissions information, or will go away entirely in the not too distant future because of cybersecurity concerns. So the telematic system is going to become the only source of diagnostic repair data for the repair industry in the future. And so
when is-
access to, we don't even know at this point how far that will go, but we do know that the OBD system will be limited in the future.
What is this new system and when is it coming?
Telematics is already on vehicles
Right.
now, and it just transmits the diagnostic data, health data of your car through some of the same units that the entertainment. Every vehicle is different, the way they're configured, but it sends the data to the manufacturer. And for the independent repair market, it's going to pose a lot of challenges and could require us to try to either go through, to find ways to obtain that data from the vehicle, or we'd be forced to just go through the manufacturer server to get that data, which is at their, terms.
So what I'm trying to understand is whether you agree or disagree with Mr. Keeley, where he says the entertainment module is totally separate from the brake module, and he would like to be able to offer repair for both of them. Are you currently, or do you think there's currently a prohibition or an inability to engage in repairing the brakes or, any type of vehicular repair because there is a prohibition on circumventing the telematics ECUs?
Well, I guess right now, because we're still able to obtain data from the vehicle, that issue probably is not there. But right now, we're slowly seeing. We've already seen BMW announce that they're going to take away the OBD system. So, yeah, that could inhibit the ability to repair a brake module if you can't get the data to know what's wrong with the brake module.
And
So currently, yes, we can do that, but that's only at the current moment.
Okay, so you've a couple of times referred to a change going to be coming in the future. Is this going to be done on an auto manufacturer by auto manufacturer basis? Is it a standard?
Yes.
What is this change? And
It's just
how
the
do we know that it's-
manufacturers trying to address the cybersecurity issue, and it's vehicle manufacturer by manufacturer attempting to do that, yes.
So
It will be different. There's no standard telling them that you have to do that. It's a question of how they choose to address it. And we're already seeing manufacturers announce that they're heading in a certain direction. So it's not a fear that were created, it's things that were actually being discussed.
So you mentioned BMW. Is there anything else in the record where if we want to look into this?
I can give you the presentation where BMW talks about it, if that gives you some assistance.
No, I'm just looking to see what's already, I guess, in the record. So BMW, are there other auto manufacturers?
That's the only one I actually have at this moment in writing. The others are just ones we've seen. There has been others that we've seen kind of come and go, but in presentations, but I don't have those.
I just want to make sure I understand. So you're saying that increasingly or in the near future, it's going to become necessary to access telematics data in order to repair a vehicle.
Correct.
And you're being inhibited from doing that currently because of the limitation on the current exemption.
Well, currently, we can't get access to the telematics system. I mean, that data, we would not be able to do that currently. Correct.
Okay. So what about the entertainment system? Is the concern there that,
What about
the entertainment system? Is the concern essentially that you want to be able to, like Mr. Keeley, I guess, alluded to, that people want to be able to repair the entertainment system, and that's just a limitation? Is there anything else that you are seeking to do with respect to the entertainment system?
The only thing, I mean, right now, those units, the telematics systems, every car company configures their system. Some of them are entertainment systems are very separate. Some of them might be tied into the rest of the vehicle. I think from an entertainment system, the actual entertainment device that's on the vehicle, those are, those would have to be remanufactured and then reinstalled. And I think Mr. Keeley is talking about the fact that it would be difficult to do that, to make sure that device does what it was doing exactly the same for the motorist without being able to circumvent that software. But I'm not technically the right one to ask. Mr. Keeley would have a lot more knowledge of that than I would.
Okay, Mr. Turnbull's had his placard up for a bit, and then maybe Mr. Williams, if either of you could help explain your understanding of the technology, whether allowing circumvention of this telematics ECU goes right into the entertainment system, or whether there's separate TPMs protecting it such that it might be possible to repair the car-related things without getting into the piracy of music, such as you've have submitted information on.
Not sure I can answer that question.
Okay, well,
But
either way.
what I'm concerned about is the getting into for example, a Blu-ray player that may be built into the entertainment system of an automobile, and that in the name of repair, somebody would modify that in a manner that would not otherwise be permitted, or it's not in other words, if it's restoring it literally to the same functionality, meaning all the same outputs are protected, all the same, inhibitions of various kinds are incorporated into that, it becomes something that maybe, but I would also say that I think both of my clients would be very interested in entering licenses with people who want to do this. And we have a very open license process. We have non-discriminatory and all of that. To my knowledge, no one has ever come to us to ask for a license, which would be a way of dealing with the entertainment part of this.
And what license would that be exactly?
There would be a license to use our technology under the requirements and the rules and that sort of thing. It would allow access to the specifications. It would allow access to the all of the requirements of the systems. And if you wanted to wanted to repair a system, it would allow you to understand how the technology works.
So I don't want to get too far away from vehicles. I know we're talking about those specifically, but I just want to make sure I understand. So your view is that you wouldn't object to an exemption that included repair and that included DVD players. Is that?
No, what I was saying,
Because I know that-
what I was saying, and I maybe not as articulately as I might have, but was that to the extent that the exemption does cover those, that it would be absolutely critical that it be limited to restoring the system to exactly how it existed before and all.
Is that possible? If you're looking through code and the code is buggy and you're trying to fix it, is it possible to restore it to its original function and then put
Maybe not in a computer programmer's terms, but in terms of, for example, does the output that from that system, if there's a connection to some port, is that output protected? So, or have you cut off the HDCP protection so that it's now spewing out clear text data?
So you're looking, sorry, for it to be restored to its state from a functional perspective, including the same locks on it, as opposed to from a code perspective. And does everyone agree that would be non-infringing under 117? Is that the proper way to look at that language? Okay.
So we've been concerned, as you can imagine, with sort of trying to differentiate between embedded software and devices that sort of where the software exists to sort of control the operation of the device on the one hand, versus, on the other hand, things like video game consoles and DVD players, types of devices that give access to more traditional creative expression. And so what we've been told, we've had comments from ESA where they've said that, at least in the context of video game consoles, the TPM that controls the access to the firmware is also a TPM that controls access to audiovisual works, to video games, the content in video games. And the concern is, that their argument is that, if you allow circumvention, even ostensibly for the purposes of repair of a video game console, you are allowing access to, you're essentially not only allowing circumvention to allow access to the computer code, but also to audiovisual works in the form of video games. Do you share that concern with respect to DVD players? I mean, I would have thought that the DVD players, the CSS system, as I understood it, also acts as an access control for the movies and the content on DVDs. Are you saying that it's possible to circumvent access controls to the firmware controlling the operation of the system and not interfere with the CSS?
I think it would depend on the player, and it would depend a little on what the problem was. I could imagine, for example, if there was some problem with the power source and you needed to repair the power connection, you might need to take apart a DVD player and effectuate that repair. That wouldn't necessarily, and probably from my understanding, wouldn't interfere with the ASCS or CSS functionality of that product. Now, I don't know whether anybody would ever put a TPM around the power source, but there are, and if there are, for example, you've got a player that has Blu-ray functionality and it's also a music player. The access, in at least some players that I'm aware of, those are completely separate functionalities on the player, and you wouldn't have to touch AACS in order to repair the music functionality of the player. What I was trying to get to before was just that to the extent that we would be concerned if there was a broad brush exemption to say, oh yeah, well, do whatever you want with the telematics infotainment system, because of the concerns that car manufacturers are only providing the car repair data through that system. It seems to us that you can slice that and say, to the extent that you're going to do something to deal with the problem that Mr. Lowe was talking about, you want to be very clear that is not also sort of slopping over and covering, an AACS Blu-ray functionality.
Mr. Williams?
Thank you. I cannot answer the question about the technical distinction between circumvention to access the telematics versus accessing the entertainment system. My understanding is that when we're in Los Angeles, the witness from Harmon can speak to that better than I can. I think it's important to look back at what you did in 2015, which is you looked at the record, you concluded it was sparse with respect to entertainment systems. On top of that, there were concerns about unauthorized access, unauthorized copying. Those two things together led to the exclusion of entertainment systems from the exemption. I think the record's probably even sparser this time on the need to repair these systems. I didn't see any examples in the written comments about that need. And the concern about unauthorized access is still there. The one thing that I did see a few times referenced was not about repairing an entertainment system, but about modifying it so that you could turn it into some kind of storage device. I was a little unclear on whether the goal there was to be able to copy the motion pictures or the music that you're watching, or whether it was to basically turn it into a blank slate so that you could upload new content to it. That I see as not a repair but a modification, and I also see as something that's rather threatening to copyright interest and really isn't necessary. My also understanding is that, and I'm not technically expert at this, but there's not a lot of excess storage space to be used on these entertainment systems. So I don't think that example standing alone is enough to grant an exemption. We did submit a statement from Warner Music, their CTO, in this exemption, and he spoke directly to the fact that from their point of view, the lock on the firmware on an entertainment system in a vehicle is part of the content protection system that they rely on and they credit when they're thinking about this from a copyright owner's point of view. It's not just something that they have no interest in locking someone into using any particular provider for repair. There's no competitive reason that my clients have to care about whether someone hacks that firmware. The issue is that they do believe that once that firmware is hacked and the entertainment system is accessed, especially when it's accessed for modification, that bad things can happen, that streaming service can be accessed in ways they're not supposed to be accessed, copies can be downloaded in ways they're not supposed to be copied, including from subscription services. Our concerns go beyond just competitive issues and go directly to the copyright interest.
Thank you. Could I follow up on that last point and Mr. Bell's statement specifically? I mean, reading his statement, I didn't get the impression that that the companies you represent are directly involved in developing the access controls that exist on in vehicle entertainment systems. I mean, I'm looking at paragraph 5 on page 2 of his statement. He says, although WMG is not privy to the precise methods used to securely communicate or store such keys / token on every device, it is my opinion that obtaining root access to the firmware on devices used to access streaming music services may lead to compromise of the above referenced protection schemes. So I guess what I'm asking, I mean, these aren't your TPMs. So should that affect our analysis? I mean, I understand that maybe, you know, the content that you own may incidentally benefit from TPMs that exist that protect access to the firmware on the entertainment system. But is it appropriate for us to sort of consider, you know, sort of downstream infringement of those types of works, given that you're not the party that, I mean, am I correct, I guess, in reading his statement to suggest that you're not really involved in developing the TPMs or you know, have any role in establishing those? The access controls that exist on the firmware on the entertainment system.
I don't think that's entirely correct. So I'm here on behalf of the Trade Association, which is made up of multiple members who, of course, are competitors within the same industry, and I'm not privy to all of their individual contracts with the device manufacturers or with the streaming service providers, for example. My understanding is that the members would look for some level of protection to be promised by the service providers and or device manufacturers. Whether they actually get to consult on the individual TPMs that are used, I can't say for sure, but I'm sure that they would like to be involved in that process. So I don't think that they're just incidentally protected. I think the device manufacturers, in consultation with the subscription services and others, would work out an ecosystem that they feel meets whatever contractual obligations they may have to provide protection on the content. I don't believe the content would be licensed unless there was some representation of the ability to carry through on the nature of the license, which is usually limited to access in very specific ways, certain numbers of copies, certain numbers of time-limited downloads, whether you have premium access that involves no advertisements or a lower level of access that involves advertisements. And so I think there would be some level of protection built into the licensing structure. I don't think that the record companies or other copyright owners would have complete control over exactly how that's implemented. And so I think what Mr. Bell was trying to say is that he doesn't necessarily know how every little piece of the system might work, but that his expectation going into a deal like that is that there will be protections in place, and that one of those protections, in his view, is the underlying lock on the firmware.
So I see a few placards up, and I wonder, does everyone want to speak about vehicles specifically? Because I think then we'd like to move on to Mr. Turnbull. You do?
I want to answer the particular question that was just posed.
Okay.
And make it clear that Both AACS LA and DVDCCA are consortia, in one case an LLC and in the other a 501c6, including studio and, members, and so they are very much, the AACS and CSS are very much the interest of and property of, if you will, the content owners as well as the and in both instances, the content owners have third-party beneficiary rights with respect to every implementation of the system, in case that it's not implemented the way it's supposed to be.
Yeah, and that's helpful, and I understand that that's true with respect to your association and DVDs and DVD players. So I guess what I'm asking is whether that situation and the situation that exists with video games is different from one in which content owners, music companies are allowing content to be streamed to vehicles through services like Pandora or Spotify or Sirius Radio. It doesn't seem to me that there is the same level of involvement in sort of, and you can correct me if I'm wrong, in developing the TPMs, or in any case that that whatever TPMs Sirius and Pandora may have are sort of tied to that particular service and are separate from whatever access controls exist on the firmware on the entertainment system in a vehicle.
I think that the office has been wise to look at video game consoles as a unique ecosystem and has done a good job with recognizing that the access controls in place there are all designed to further a copyright interest, both in the games and also in the other types of expressive works that you can get to through a console now, such as motion pictures and music. And in that market, you can look at the actual consoles as part of the video game ecosystem. There are multiple types of expressive works accessed through a vehicle entertainment system as well. And I do think, as I was just saying, that the copyright owners who make their works available through those systems take into account the various layers of protection before they go into licensing agreements. So that, I think, is similar to the video game space. It's not exactly the same market, but it's that my clients' members look for protections to be in place before they enter licensing agreements, and I think that's also true of the video game space.
Mr. Shore?
So I wanted to comment on the video games because, thank you, Jonathan. Wanted to comment on the video games because it strikes me that the industry, the video game industry, in response to consumer complaints several years ago, where customers weren't going to be able to use their games, port them from one person's house to another because the DVD has sort of gone away and now it's all stored in the cloud. They've made that available to consumers. You can play your game on my machine or on Jonathan's machine because you're not really accessing it on the machine. You're accessing it in a cloud storage system. So I don't understand how you can kind of have it both ways. How can you say that the system is tied directly to the games, and then but it's not tied to the games because you can take it from machine to machine? I'm unclear on how you reconcile those two things.
Sure.
My understanding is that an unjailbroken console would recognize whether or not the copy that's being played is authenticated and legitimate, regardless of whether it's accessed through a disk or through a remote server. And so the TPMs on the console still further the copyright interest, regardless of the method of dissemination.
No, but it's not the TPM. It's the fact that I access it with my username and my password, right? that allows me to access the game regardless of the machine. I mean, I don't think you can sit there and say that that the machines, well, I'm not.
All right, Mr. Brand, anything you would like to say about the telematics and entertainment uses, and then I will ask a general question to you about expanding to other devices and what specifically is in the record. What are you, what is ORI sort of looking to do? Is this, there's not proposed regulatory language, so I wonder, would it be consumer devices or firmware on a device, or how would we write this regulation if we were to recommend exactly what you're asking for?
Okay, so first, I'll first respond to the telematics, and so in that sense, in that context, I just said that I have great confidence in the Copyright Office to come up with an exemption that gets to allowing or preventing users from being and car owners from being locked into always going back to the manufacturer and the dealer, but while at the same time not allowing sort of like a torrent of hacking of the entertainment devices that will lead to infringement. But beyond that, I think it's really important as you're fashioning the exemption and tinkering with the wording to realize we have a little bit of a tail wagging the dog problem here, which is, okay, so there's no question that there's infringement out there, and there's no question that there's infringement of Blu-rays and Blu-ray discs and DVDs to a probably lesser extent now as that technology is going away. And I guess streaming. I mean, yeah, that all happens, but there's a lot of it, right? The amount that's ever going to be happening by virtue of what's going on in the car and somehow hacking the entertainment system in the car is going to be a drop in the bucket relative to what's going on out in the world. Now, weigh that against the fact that here we have, this, every American has, or not every American, but a lot of Americans, the vast majority of Americans have cars or access to cars. They need to, it's their largest investment other than their house, right? And, spend huge amounts of money in repairs and so forth. And to what extent are we going to restrict competition in that market, in the repair market for automobiles and all kinds of other devices, because there's some slight possibility of some slight amount of infringement relative to the vast amount of...
Just for a moment, I hear what you're saying, and what I think one thing we're trying to put our finger on is how are these Americans being prevented from repairing, diagnosing, or modifying anything having to do with this car they've owned as opposed to their Sirius subscription or the DVDs. So can't we just leave the line exactly where it is drawn and enable those beneficial uses without, I guess, risking the entertainment content? Like, is it necessary to tinker with the language to achieve what you're talking about?
Well, I would certainly say...
And where is it in the record specifically?
Well, the telematics, I think, is the problematic. Entertainment is more discrete, but telematics is sort of this broad, undefined area, and especially as we were getting to more and more autonomous cars, I imagine all that is arguably telematics. And
but there's nothing in the record about autonomous cars in the next 3 years, so...
Well, but again, the term telematics sweeps in a lot, and a lot of these systems are bundled or will be bundled, and so then and there is I do recall seeing something in the record about these systems being bundled together, and then that can have an impact on what you're able to access, and that there's the problem of overbreadth. So do you want to,
okay,
Mr. Lowe, have Mr. Lowe answer that, or do you want to go to the next?
If we could maybe move on to devices on Mr. Lowe, unless it can be very quick, is there something?
Yeah, I just want to, I guess, add that the problem is that going along and defining them separately is becoming an issue because the vehicles are becoming, the entertainment systems is becoming intertwined with other systems. I mean, now a car owner goes on their app and they can stream music through their system, but also get health data from the same system on their car. And so the defining the line, because of the way the manufacturers are designing their vehicles, become big entertainment centers and big computer, information sources, or being able to control things from offline. I guess the Internet of Things. It's making it harder to define that line anymore. And we're not interested in, music or hacking to get Sirius XM or any of that. But if that definition then prevents us from repairing a vehicle's car, or getting data so that we can repair the vehicle's car, then we're interested. And we're just seeing the car's systems becoming more intertwined with their entertainment systems. And I'm afraid that the way things were 3 years ago are not the way they are now, or the way they will be in the next year or two. Technology is advancing so quickly on these cars that the definition is becoming more difficult. So we're interested in finding that definition to make sure they're protected, but at the same time, we need to be able to repair that car as they're being configured now and in the future.
Okay, so let's go back to Mr. Band to talk about, again, in a perfect world, what would this regulatory language say? Would it be software on just software period, or software on embedded in a device?
It would be like software that is necessary for the operation, or contained in and controlling the function of machines. That it would just be broadened, that it wouldn't be limited to the motorized land vehicles.
Would it have to be by the owner or authorized by the owner of the machine?
Well, I mean, we have the same third party, or authorized by the owner, yes. I mean, we obviously would have the same third party repair issues. So
right, but there'd be some authorization requirement. I mean, you're not asking to go repair an ATM machine without telling the bank or anything like that, right?
Yeah. Right. No, it would basically be, it would sort of, that again, that if you own a machine, you should be able to get it repaired wherever you want it repaired. That you shouldn't have to go to the authorized dealer, because that's always going to cost a lot more.
I guess there's a couple of questions, because there's different levers we're playing with, because you also would like to make improvements, and would the owner have to make the improvements themselves, or would a third party be able to do that?
Now, again, that's just consistent with the previous discussion, that you should be able to get third-party assistance. I mean, that's in terms of what would be the desirable exemption.
And maybe you could talk a little more about what's specifically in the record. For example, the written comments made a reference to compilations of data, but I don't know that there's any record supporting the need to circumvent something protecting compilations of data, or the specific types of devices, since we need to draw something based on whether there's likely to be non-infringing uses, what types of machines.
Right. So the members of the ORI are companies, are associations like the Association of Service and Computer Dealers. So they repair servers, for example, and or routers, or switches, or again, there are members who would be repairing.
So your members are not individuals?
So our members typically would not be the individuals. These would be the people who would be in the service business. So they would want to be the people who would be providing the circumvention service. But they're not in the circumvention business. They're in the repair business. But to do that, they would need to engage in the circumvention. But we also, we also represent the interests of the owners themselves by allowing them to exercise ownership rights in their property.
Could I ask about the modification aspect of your proposal? So, I mean, as you know, in 2015, we we recommended and the librarian granted an exemption that would extend to modification, that would allow circumvention for the purpose of lawful modification of a vehicle function. And we, as we talked about, excluded the entertainment system and the telematics because we were comfortable, I think, that if you're talking about, if you're sort of cabining the activity to modification of a vehicle function, something that controls the operation of a vehicle, we were comfortable that that was likely to be non-infringing as a general matter. I think the concern is if we expand that to all devices, can we sort of say categorically that any modification of software embedded in the device is categorically going to be non-infringing? And I understand sort of an answer to that is to say, well, we could define the exemption as non-infringing modifications, but does that get a little bit circular, I think? Our job is to sort of, identify a class of non-infringing uses and to determine whether that activity is non-infringing. So if we just sort of say, well, you can do whatever you want as long as it's non-infringing, are we sort of kind of exceeding the scope of this rulemaking?
No, I don't think so, especially if you say you define the modification for a modification for the purpose of engaging in a non-infringing activity. And especially if we're talking about refrigerators and toasters and those kinds of devices, I mean, there is no possibility of infringing activity to begin with. So I don't see a problem. I don't think that this would lead to abuse. And I think, again, this is just a recognition of reality, that we're sort of moving in this direction, the society is moving in this direction, technology is moving in this direction, and again, it was never the intent of Section 1201 to in any way sort of regulate the U.S. economy and restrict the ability of restrict competition and in repair and aftermarkets in the entire economy.
In the case of a software product where the software copyright owner has the exclusive right to prepare derivative works, how would this proposed exemption tread on that or not tread on that? How could we protect that ability, which I think 1201 was also not supposed to change that contour?
So, explain the example and what is it?
You've listed toys, right? What if you change the software in a toy to do something else that is expressive or speak in a different language if it's a talking toy? Is that likely to be non-infringing? And does it matter if it's commercial or if it's just, me changing it for a toy that's in my house?
Well, I guess, I suppose, depending on the situation, that you could end up engaging, it could be in creating a derivative work, and that would be non-infringing, and that would not be permitted.
Mr. Williams?
Thank you. This is a big topic, and I understand we're going to spend some time on it in Los Angeles.
Correct.
But I just wanted to briefly respond to some of what Jonathan's had to say. I appreciate that Jonathan is not interested in enabling unauthorized access to the types of products and content that my clients disseminate, and that he acknowledges that 1201 at least is about not only infringement but also unauthorized access. But my point of view, and I think the point of view of the office in the past, has been that the proponent has to draw a distinction, define a class of works that the office can look at and say, okay, that is not going to harm copyright owners, and that is a definable subset of copyrightable works or devices. And the current proposal to just cover all devices for any type of repair, any type of modification just goes very far beyond that. So in our opposition, we said, well, at the very least, exclude devices that access expressive works of the type that my clients distribute. And make them.
I mean, we cannot write in a regulation except for devices that include content that your clients distribute. I mean, how would that work?
We said expressive works, and then I was saying of the type that my clients are interested in. And the response was, well, there's lots of general purpose devices that you might also be able to access those types of works through. And I think that might be true, but there's nothing really in the record about a need to repair or modify those types of devices. Even with respect to laptops, I think there's about 3 sentences in the EFF submission that says that in some circumstances someone might need to circumvent to repair a laptop. And I just don't think that record has been established. And if they want to expand this beyond automobiles, which we did not oppose renewal of the automobile exemption, I think they have the burden of defining some category of devices that will not harm copyright owners. And I don't think there's enough evidence to come even close to doing that. If you go through the EFF submissions, there's a small handful of very specific devices that they've identified that they want to facilitate repair or modification of, and it's really just modification. There's very, very little on repair. And some of them, I don't think, just based on the very small amount of information they provided, would even be non-infringing. I don't think that circumventing to modify the software in a robotic dog so that it does additional things that you want it to do is necessary.
Mr. Band just said it might be infringing.
Excuse me?
Mr. Band just said it may be infringing.
Right. So, and in the 1201 study and the software study, you've said it's very difficult to draw a line between embedded software in devices that are not furthering traditional copyright interest and those that are. And on that basis, you decline to exclude software and embedded devices from 1201 as a recommendation.
Well, we have, for example, granted a jailbreaking exemption for multi-purpose devices and smart televisions and certain other devices, but excluded it for video game consoles, for example. Why couldn't we do something similar here? And I keep looking to Mr. Van because his comment was joint with EFF, but they talk through Internet of Things, appliances, peripherals, computers, toys, vehicles, and environmental automation systems. I mean, it may be a little bit of a mouthful, but why not list that and say excluding devices that are primarily, media playback devices or whatever, however we term this expressive content device.
Right. So I think if you were inclined to do that, and I don't think they've built a record to justify you doing that, I would come at it in the opposite direction. Instead of trying to exclude media playback devices, I would look at the record. I would say, here's the exact types of devices that they've identified, that they provided evidence on. I'd go through each of those examples and see whether, like the robotic dog, it might be infringing, or like another product like a light bulb, maybe it's not. And then I would include a specific list of devices, the way you did with automobiles. I'm not saying you should do that again, but that's more of the approach that I would take. I also think that since the exemptions were granted in the spaces that you're referencing, we now have a new opinion from the Federal Circuit applying Ninth Circuit law in Oracle versus Google, and I would emphasize that I think you should take a careful look at that, because it approaches software modification and software copying, I think, in a different way than the office has looked at it. And I think it might shed some light on the fact that just because someone wants to copy and modify software doesn't mean that it's non-infringing, just because the software might have some functional aspect.
Does that really bear on the case of a non-commercial use? I don't know that would, just to start, there's obviously a lot in that opinion.
I'm sorry, you said on a non-commercial use?
Right.
Well, I think it would, because I think the discussion of commerciality in the opinion is only a piece of it. And if you look at that, they're actually very express about the fact that commercial in the fair use landscape doesn't only mean that you're out there selling a product in the market. It also can mean that you avoid paying the customary price for the conduct you're engaging in. And so I think even that issue is a nuanced issue when you read the opinion, but there's also a lot in there that goes beyond just pure commercial conduct.
So, Mr. Turnbull, I think you were next, but if it's okay, could I just ask Mr. Ban quickly to respond to what Mr. Williams said, and specifically, do you think it's feasible to sort of define the exemption so as to exclude devices that you know, provide access to works other than computer programs or something like that? Is that sort of a feasible approach, or would that exclude more than you think is necessary?
It could possibly be worded in a way that, certainly in terms of entertainment products or entertainment software. I mean, you know, there probably is a way to word it so that it doesn't, so that it's much less likely to tread on the interests of that industry, or again, that you know, that would facilitate again, you know, facilitate infringement, which at the end of the day is what this is all really about. But I just wanted to also just respond to two other points. One is, you know, in terms of Oracle v. Google, I wasn't expecting to talk about that today, and I think it's wrongly decided in 25 different ways, and so we can, we can talk about that at some other point. But I do think that in terms of the record, and in terms of sort of like, how do you approach this? Do you kind of approach it by saying everything is permitted or everything's prohibited? You know, do you have a long list or a narrow list? I think, again, you know, we're here because Congress sort of, you know, perhaps unfortunately decided to start with a very broad prohibition on circumvention. Instead of saying circumvention for the purpose of infringing activity, which is what they should have done, that's not what they did. They instead came up with this really broad prohibition, and then with a few specific exceptions, and then with this rulemaking. So they took this, you know, huge broad brush approach, and now we're sort of dealing with this, trying to clean up this mess, frankly, that no one ever intended, you know, whether it's automobiles or whatever. And so I think given that, then at least for this exemption, when you're dealing with embedded software, I think it does make sense to start with a broad exemption with a few carve-outs as opposed to a narrow exemption with, you know, where you can say, okay, well, here we have an example about a thermostat. So we'll allow thermostats, but not other, you know, household systems. I mean, I just think that that's completely unworkable. And in terms of the evidence, there is a bit of a chicken and egg problem here, which is, okay, here we have a broad prohibition, and then you say, well, give us examples of people who are breaking the law or who want to break the law, or, you know, I mean, so we know we have this huge auto repair industry, and this industry's been willing to step forward and say, you know, we need an exemption to provide the service. But, you know, I've got to believe that if all this is going on in the automotive area, it's going on in the you know, the motorboat area, right? Because those engines are just as complicated.
So I appreciate that perspective, and some of that I think is relevant to the policy issues and the policy study of what the statute should be. But here in this rulemaking, we have to look at whether or not there is adverse effects and non-infringing uses. And the Commerce Committee report says those should be distinct, measurable, and verifiable. So the Copyright Office cannot necessarily grant an exemption based on, I've got to believe. We've got to look at what evidence there is, and we will look to everyone to tell us the burden of production and how these TPMs work and what is going on. So I wonder, tying into that, if you can provide what devices is there a need for repair or for modification? Do your I guess member companies or I don't know, your members, do they have competitors who offer authorized repair services already? Are consumers finding it difficult to get their appliances repaired?
So, yeah, it is an ongoing issue in the computer space where, and this is, goes back to Section 117 and MAI versus peak. And I mean, this is a long-term struggle between the independent repair folks in the computer area, in telecommunications equipment, and the original equipment manufacturers and their authorized repair people, and it's a constant issue. And so whether it's, an issue that keeps on coming up now is that if you repair a Cisco device with a with a perfectly compatible piece, but it's not a Cisco piece, that you get an error message, right? And then that sort of causes the users to freak out, and they say, wait a minute, why am I getting this error message? And now, is that an effective technological protection measure? I don't know. Probably not. But
if it's not, then do you need an exemption to circumvent it? I mean,
well, probably not. But that's just an example of the kinds of there is this ongoing effort by manufacturers to prevent independent repair, and our understanding is that there are other technological measures that people might have to repair, but people aren't willing to sort of raise their hand and say, yeah, I'm doing this to engage in this kind of activity.
Can I ask, how would your proposal apply in situations where where a TPM is controlling access to more than one type of work? So it seems like that is really at the heart of the concern here, I think. To the extent we're talking about software that is embedded in a device and does nothing other than to control a device function, that's one thing. But if the same access control is preventing access to something other than a computer program, it's protecting access to more than one type of work, how would your proposal apply in that situation? Would you say that you should still be able to access the software, notwithstanding that it's controlling access to another type of work, or would you be limited to computer programs that are controlling the device? Is it feasible, and if it's the latter, is it feasible to limit it in that such a way, or does that sort of throw the baby out with the bathwater in terms of what you want to do?
Well, again, it's hard to talk in response to a hypothetical like that, but I suppose I'd say, we would want it as broad as possible, but we would understand that you would be limited by, A, the statutory authority, and B, the competing interests. And certainly at this point, we're, looking at sort of like based on the wording of the existing exemption and saying, okay, contained in and control the functioning of. And that's what we're talking about, and sort of, but not going beyond, the motorized land vehicle, because that seems unduly narrow.
I actually have one question on that, just going back up maybe to cars. I apologize, but so MEMA and AFBF have requested, I think, language saying that control or assist in the functioning of, or maybe Mr. Lowe, you said that facilitate the function of. Is there any specific examples of things that you would be able to do if we added that language in that you're not able to do now related to cars or other devices? I'm wondering, is control the functioning of specific enough already?
We submitted this testimony, or was it MEMA?
It was AFBF and Auto Care Association with CTA. You said control or facilitate. It may have been inadvertent.
To control, so to modify the code.
Yeah, why is the word facilitate? What is that? What work would that be
Well,
doing?
I mean, an example, I think what we're talking about, it was an example like the Farm Bureau submission, which talked about the gentleman who developed an emissions control device that would reduce emissions from agricultural equipment, and would have to modify the code to accept the new part on that car, but would not be able to do it under the current system.
Okay.
Okay.
Mr. Williams?
Yeah, I just wanted to quickly address something Jonathan mentioned that I think kind of highlights the difficulty with the line drawing that would be involved with trying to carve out certain types of devices and then cover all the others, which is, he referred to trying to exclude entertainment works. And that's very important to us, of course, but we also are here representing book publishers and journal publishers, and they produce entertainment-related novels. They also produce very scholarly-oriented textbooks or things of that nature that wouldn't necessarily be treated as entertainment. So if you just excluded devices that access entertainment products, they might not be carved out. And so I think that kind of line drawing is very difficult to do. And again, I think it should be on the proponents to offer a workable definition. Otherwise, I think you should take a look at the actual devices in the record and see if they've met their burden.
Sure. Well, I mean, you used the phrase used to access expressive works, and obviously, like a refrigerator is not typically in that category, and repairing the software on a refrigerator, I don't know if there's, improvements you can do to your refrigerator code. I mean, if there was a sufficient record on that, would that, as we consider the statutory factors, I'm not sure how that would be risky, I guess, to the availability of copyrighted works generally, or to, things that your clients care about.
Sure. Yeah, I appreciate the example. I think there are now refrigerators with TVs built in, but setting that aside, I think, yes, if there was a sufficient record on refrigerators, and if you looked at that and you could tell what the proponents were looking to do, and you felt the need to grant an exemption, we wouldn't necessarily have an objection to that. I do think when you're talking about modifying the software in the refrigerator, you get to something that's quite distinct just from repairing it and restoring it to the normal functionality that it had previous to the circumvention. But yeah.
But what about my question to Mr. Band? I mean, why, rather than having to sort of delineate different types of devices, could you just say, and we could be clear about this in the, in the text of the exemption, this applies only to circumvention of access controls to computer programs controlling, the functioning of a device. And if the same TPM that controls the, operation of your refrigerator also somehow controls the refrigerator's ability to get Sirius radio or whatever, then you're out of luck, because it's also, we haven't granted an exemption allowing you to circumvent access controls to anything other than a computer program. So, and you're sort of at your peril to determine whether this access control is limited to the firmware or it controls something else. What about that approach?
Sure. I mean, that's certainly preferable to what has been requested. I think there are some problems with it. So, as we've discussed earlier, you've gone through previous records related to video game consoles. Accessing that computer program on the console to modify the console ultimately results in unauthorized access to video games. Now, video games are computer programs. They're also audio-visual works, so maybe proper drafting would exclude video games because they're also audio-visual works. But I'm sure that there are also all types of expressive computer programs that unauthorized access could be enabled to through circumvention to access some other computer program. So I think we're always willing to take a look at drafting and respond to letters and try to be helpful, but I don't see that as necessarily a perfect solution.
Yeah, Mr. Turnbull.
Well, now 2 points. One may have passed the discussion by some time ago, but I was originally put my card up to respond to Mr. Band's formulation that talked about circumvention for any non-infringing activity, and simply wanted to make the point that in relation to DVD and Blu-ray, exemptions that have been formulated precisely that way have been rejected uniformly by the Copyright Office and the librarian, and I wouldn't want this to be some kind of backdoor to that kind of broad-based exemption. The second point, however, it came up just now, and that is that I think you need to be careful because Blu-ray players, DVD players have what would normally be called computer programs and firmware. And so, those control the CSS and the AACS functionality of the product. And so I'd be concerned about an exemption that talked about something that a computer program that controls the functioning of the product, and including firmware for that, because that would include the AACS application on a Blu-ray player.
Is that right? So if you were to circumvent AACS, it would go on a player by player basis as opposed to a work by work. It's not movie by movie. It's the specific Blu-ray player would get, I guess, its keys revoked, or how does the technology work?
I'm sorry.
For that?
A Blu-ray player, taking our latest incarnation, the AACS2, which we'll have some discussion about tomorrow, but there are requirements that the firmware be upgradable, so that if the player turns out to be hacked for some reason, that the firmware implementing the AACS functionality must be upgradable so that can be corrected, what you're actually doing is downloading a new computer program.
Thank you. Mr. Shore?
Yeah. We laugh about the TV and the refrigerator example, but if you don't adopt a broad definition, ultimately you could end up with a system where the refrigerator, the microwave, all of these sort of rote technologies that we don't really think are problematic, you end up embedding some sort of technology that could be used to access creative works, and then it's thrown out the window, right? Then you can't have that particular refrigerator because there's either a controller in there, or it has a TV, or it has some system by which you can, hack Pandora. And I think that's a pretty perverse incentive to, bless you, pretty perverse incentive to start really rolling back and limiting what devices people can then repair, use third-party maintenance to repair.
And do you have a sense for whether these devices, right now, there's a need to repair them, or there's a need for third-party repair?
Well, there's a pretty, we actually have a study we did a few years ago on the size of the resale and repair market that would be happy to share. It wasn't directed at this particular issue, but it would give you some sense of scope and scale of what's out there. What's that?
Was it submitted?
No, because it wasn't done for this purpose. It was something unrelated, but it might be of interest to you. But it's a pretty sizable market, and it extends beyond just computers. It's refrigerators. It's the technology in your home. But it's also a lot of. We're not talking about just laptops. We're talking about multi-million-dollar robotic arms that need to be repaired, and machines of that magnitude. We have members that do repairs for government agencies that have very complicated technology systems that are off warranty, or that need a part that isn't made anymore in order to make the technology work. So, but I'm happy to share with you.
Well, I guess in that example, Section 1201 is not posing a barrier because it's going on, right? I mean, what are the types of repairs that I guess there's a need or a desire to do that cannot currently be fulfilled because of Section 1201?
Well, it's the things that are members, servers, routers, computers. I mean, all of the things that the other side claims could be used to then access protected works. We have, you can drive up and down any street in Northern Virginia and you see these shops, some of whom are members and some of whom aren't. And they have particular challenges, often accessing the firmware because of the limitations that are placed on by the manufacturers. In fact, you go to their websites and they tell you, that you're violating the terms of service if you access the underlying firmware.
Terms of service is separate than Section 1201. Did they
Understand.
turn people away because of Section 1201?
Right. It's always difficult to get members to, as Jonathan pointed out, to stand up and say exactly what they're doing, because particularly because most of these guys are pretty small businesses. And it's granted, it's a challenge to ferret out who is engaging in that type of behavior. There is the possibility that we could get some people to talk to you, in a private situation, but I think that we see time and time again the heavy hand of the large manufacturer in other settings, and there's a case going on at the ITC right now where some of the large manufacturers are coming after some of the smaller technology repair companies for a variety of issues.
Not for Section 1201.
No, not for 1201, but again, because it's very difficult to ask these businesses to raise their hand and admit to engaging in this type of behavior. It's a challenge. I concede that.
Okay, so I have a slightly different question, which is maybe to start with Mr. Ban, but when I read the ORI comment on modification, it is tilted towards like the personal user, tinkering with the device for their own education or for non-commercial use. And I don't really see, personally, the record having been built out to make a case for commerciality of lawful modifications. Do you agree, or how would you think that would change if it was outside of a device? You owned it, you bought it, you're tinkering with it, and you're using it yourself without distributing it?
Well, going back to, your Section 1201 study, which was very good, by the way, drawing the line between commercial, non-commercial gets very, very blurry, and it's very hard. And sort of I guess it was the computer. It was in the computer embedded software study, which was also very good. But there was an acknowledgement that drawing, saying it's commercial, non-commercial, gets very blurry in this environment where, this device, which actually someone back there lent to me,
here's an example.
it can be used for commercial and non-commercial purposes, and so that's why I'm not sure. I mean, even though a lot of the modification, a lot of times a person would want to modify it for a personal use, but it could be modifying it for a business use as well.
But I guess where I'm going is I'm trying to look at what potential uses have been submitted in the record as being adversely affected. And for example, there's a current exemption for non-commercial remix videos, which was based on a record saying people want to engage in remix videos. This is for non-commercial purposes. Because of that, the office looked at it, said it's likely to be a fair use, in fact, under the fourth factor. And so can we at least say I don't think there's a record saying there's commercial modification of devices which are not vehicles. Do you agree with that? And if there's something else in the record, let me know. Why couldn't we say if the office were inclined to allow lawful modification to other devices, that it would need to be for non-commercial use?
Well, the only, and that would be certainly a positive step if it were,
I don't know that we could say for commercial use, because I don't know that there's anything there.
Right. Well, I guess the only refinement on that is that, as opposed to the remix situation, it's where you're modifying the work. Here we're not modifying the work. We're leaving the work intact. We're circumventing. I mean, typically.
No. You have a host submission you would like to circumvent to modify software. That would be modifying the work.
Right, but a lot of times what we're really trying to do is modify the device. But I guess to modify the device, you might need to modify the software. I mean, it just depends on, but the goal, whereas in the remix situation, the objective, the end purpose is to, change, to reuse a little bit or to change the work, because that's the purpose. In our context, because, we don't care, no one cares about the embedded software. It's what you're able to do with it. And it's a device that you're controlling. And so, I think that could be an argument as to why the restriction to non-commercial is it's different from the remix situation, but it certainly is a positive step forward.
Did you want to have a discussion?
So as we've been having this discussion, it has kind of struck me that at least in the non-vehicle context, some of what we're talking about actually starts to sound kind of similar to the jailbreaking exemption and to some of the proposals around that. So I don't know if you've had an opportunity to review the record in that context. Do you think some of what you're asking for might be covered by one of the jailbreaking proposals?
Well, I mean, some of the language might be, but in terms of the activity, I mean, because, jailbreaking it's a different kind of activity. I mean, it's sort of trying to, have these different apps that could be used on a system.
Could you provide what, if not repair and if not jailbreaking or interoperability, what types of modifications specifically are you looking to do, I guess? Could you give examples?
Off the top, I'm not a technologist, so I don't know what exactly kinds of modifications. I mean, certainly our members, as a general matter, are probably less interested in modification and more in repair, but certainly like the example that Andrew gave about the robotic arms, when you're repairing these robotic, it might come from the manufacturer or originally be programmed by the manufacturer to kind of go this way, but maybe you want to now have it go this way. And that requires circumventing the technological protection measure, and it could be, or it's actually controlled by a laptop, and so you have to circumvent the software, the protection of the software and I guess that would be that, you have to modify the software to make it go this way as opposed to this way. But again, you don't care about the software. I mean, you want to make sure that it's going up or down. And I'm not sure any of the other exemptions would allow you to do that.
Yeah, so certainly the emphasis is not the same. That's true, but increasingly, a lot of these devices are obviously controlled by software, and one of the reasons people may jailbreak is to be able to run a different app or to be able to change a setting in a particular way. And I wonder if, at least in some situations, that might cover being able to move the robotic arm in a different way or something like that, which ultimately is probably controlled by software.
Certainly, it's possible that some of the activities would be, might be able to use that exemption, and then it could be, certainly as you mentioned, the interoperability exception is certainly helpful when you fall within the four corners of that exception. But this is, there's a lot of situations I think that would fall into neither of those provisions.
Mr. Williams?
I just wanted to quickly say that at least in the EFF comments, they kind of toss in a couple of sentences about jailbreaking video game consoles in this proposed class. And I think that just emphasizes kind of the overbreadth of what we're dealing with here. It covers so many things, including things that the office has built extensive records on in the past and determined are not worthy of exemptions and would lead to piracy and would lead to harm to copyright owners. Even if you only are talking about repair, there's prior records on video game console repair, and that was not a justified exemption. And there's similar record this time on that issue with evidence from ESA as to the availability of repair and really nothing on the other side. So I think you're putting your finger on kind of an overbreadth issue with this exemption. It includes a vast array of things that really need to be looked at one by one to determine whether there's harm involved.
Mr. Band, I have a question for you. Sort of getting back to the questions that Ms. Smith was asking, do you think that the 1201F, the provision in Section 1201 that exempts reverse engineering, would cover some of the activities that you've described you feel fall through the cracks here?
Well, it certainly would apply to some situations, but not, I don't think it would apply to, let's say, all the aftermarket or repair situations. Because I think one of the things is that, as my recollection is that it applies to interoperability between two pieces of software, and so would it extend if it was between software and hardware? And so that's an example of where it might not go far enough to allow.
Is there anything in the record that sort of delineates these different types of activities? Because I think that's maybe some of the difficulty that we're having in this discussion is there's not a lot of record evidence to point to about these types of activities that you argue should be included in any exemption. It's hard to know how to draw a line when there's not a full record to explain what exactly the line encompasses.
No, I acknowledge that we tried to find more evidence. As we discussed it, it was difficult to get people to be as forthcoming as one would like. But again, you have, in addition to what is in the record, this specific record, I mean, you do have your two studies, the 1201 study and the embedded software study, that do go into a lot of these issues. And so there is evidence out there.
Okay, I think if no one has any more questions, we're a little bit over and we need to start again promptly at 11:30, so we'll take a 20-minute break and then come back to discuss Class 10. Thank you.
Thank you.
This has been a presentation of the Library of Congress. Visit us at loc.gov.